Hello, good afternoon. I want to thank everyone for joining us today for a CLE on evictions and COVID-19. This is an update. We gave a CLE back in May, and this is an update on things that have changed and happened since then. So I'm going to go ahead, because it is noon, I'm going to go ahead and begin. Let me actually just click. Okay, in case you need the CLE information, it's down here at the bottom. There is a different CLE code if you're watching live versus if you're watching a recording. This will be recorded and will be available to watch later on. And you can email Brittany. Her information is at the end of this presentation if you need information about accessing the recording, but I believe it will be on HVL's YouTube channel. So first, a little bit of housekeeping. I just want to let everyone know that today I'm only going to be talking about residential tenancies. If you were hoping to hear about commercial tenancies, we will not be discussing that. The first thing we're going to cover is the CARES Act. I discussed that a lot in the last presentation back in May. It still applies, and I just want everyone to know that and how it applies now because it's changed a little bit in how it applies. We're going to talk about the CDC Eviction Moratorium. We're going to talk about Texas Supreme Court Emergency Order 25, which came out last night. We're going to talk about what limited, quote unquote, protections there are in Houston and Harris County for tenants. We're going to talk about self-help evictions, lockouts, and utility shutoffs. That's when landlords try to force someone out instead of following the route through the courts. We'll have an update on virtual hearings, why tenants still need your help even with these protections in place, resources available for volunteers, and a note on questions. If anyone has any questions, I have several of my coworkers are monitoring the chats on the Zoom and on Facebook Live. Their names are Stephanie Summerlatte and Mari Carmen. And so you'll see their names pop up and they'll be answering questions for me as we go through. I might see some also, I might not, but they will be answering questions and I will try to make some time to go through additional questions at the end, but you can ask throughout and they should answer. And I also just want to note, anyone who attends today can receive a copy of this slide presentation. But I want everyone to be aware that things change quickly. When I gave this presentation back in May, I had to update it the night before because of Texas Supreme Court Emergency Order 15 that came out on May 14th for the presentation that I was giving May 15th. Last night at 6 o'clock, I got Emergency Order 25 and I made updates based on it. And so just be aware that things change. Some of the rules expire. And so these just be aware that things change frequently, and this presentation, parts of it probably will not be valid in a year from now. So just be aware of that. Okay, the first thing we're going to talk about is the CARES Act. It still applies. That was the Coronavirus Aid, Relief, and Economic Security Act that was passed March 27th. There's a link to it here if you'd like to read any part of it. Section 4024 is the temporary moratorium on eviction filings. It doesn't have like an expiration or a sunset within that section. And so we'll discuss what that means coming up. Section 4023 is the forbearance of residential mortgage loan payments for multifamily properties with federally backed loans. That section does have an expiration within Section 4023, and it expires December 31st, 2020. So the CARES Act Section 4024 became effective March 27th, and it only applies to covered dwellings in covered properties. The last presentation I gave in May went into depth into what is a covered property. We're going to be just breezing through that today. If you want more information about like eviction basics, the process, what rules apply, I really, really strongly urge you to watch the presentation from May 15th. I did go into that, and it's also in the slide deck that we can make available to anyone who requested. And I also did a deep dive into what a covered property is. Today is going to be a cursory review of that. If you take a case through Houston Volunteer Lawyers, we will let you know if we think the tenant that we're asking you to help is any covered property that's covered by the CARES Act. You, of course, we urge anyone to check on their own, but just so you know, we have looked into that to try to see if we think that person's in a CARES Act property. So Moving on, the eviction moratorium section of 4024 expired July 24th. The eviction moratorium lasted for 120 days. And during that moratorium, a landlord of a covered property wasn't allowed to give a notice to vacate, file an eviction, or charge late fees. However, since that period's expired, like the filing of the notice of an eviction or giving a notice to vacate, like that was prohibited during the moratorium for covered properties. Now, covered properties are still covered in that. Landlords of covered properties are still required to give a 30-day notice to vacate. And that's really big because under Texas law, if a lease doesn't specify, the landlord has to give a minimum of 3 days notice to vacate. However, the standard Texas Apartment Association lease and the Texas Realtor lease, which is used in most leases in Texas, states that the landlords can give the tenant a 24-hour notice to vacate. So giving people 30 days notice to vacate gives them more time to prepare, call us for advice, and just prepare better. And so that's still how the CARES Act, Section 4024, matters and is important today. Briefly, what's a covered property? It's housing programs subject to VAWA, which is the Violence Against Women Act, and properties with federally backed mortgages. Housing programs that are covered by VAWA include public housing, Section 8 housing choice voucher programs, Section 8 project-based housing, housing for the elderly, housing for people with disabilities. There's a whole list here. Generally, people who are in a VAWA covered property have some idea because they're receiving below market rent or they're receiving ongoing rental assistance. Like a voucher means that the housing authority is paying someone's rent, part of someone's rent every month, and then they're paying another part of it. And so we normally have a good idea because they know they're receiving below market rent. It also includes these. It also includes, I'm just going to show y'all, it also includes the low-income housing tax credit properties. There are a number of those in Houston. And so there are a number of properties covered by VAWA. If you want to see cites to the codes of how each of these properties is covered by VAWA, this link right here for the National Housing Law Project does have cites to how each one is covered by VAWA. Covered properties are also any property with a federally backed mortgage. That includes HUD loans, USDA, FHA, VA, Fannie Mae, Freddie Mac, and Ginnie Mae. We hear a lot of people refer to Fannie Mae and Freddie Mac. There are more federally backed loans, and everyone needs to be aware of that. So, and that can be if it's serviced or owned by a federal agency. So if a federal agency is connected to the loan, it is a covered property. The issue is that most tenants don't know all the time if they're in a covered property, especially if it's a federally backed loan, because who knows? I mean, I would challenge anyone who rents, you know, that's watching this presentation today to tell me if they know if their property is covered by a federally backed mortgage. So it's an issue, and it's not always publicly available. There are some publicly available databases, and I have a link to many of them here based on what's publicly available. Since the CARES Act was enacted, Fannie Mae and Freddie Mac have made it easier for people to find out if their multifamily properties might have a Freddie or a Fannie federal mortgage, but not for that's not an option available to people who rent single family homes. So a multifamily property is a property with 5 or more units. So that's your apartment complexes, but plenty of people rent homes. Those homes, you know, just a single home, are not on these lists. The TRALA, Texas Rio Grande Legal Aid, has a really nice search our map tool. The National Low Income Housing Coalition also has a nice list. This one right here is the low income housing tax credit properties. This list is actually the one that, to my knowledge, is comprehensive. Some of the others don't necessarily include every property that might have a federally backed mortgage. So, and that includes the Fannie Mae and Freddie Mac. Not all this information is completely accurate. So just be aware that just because a property does not appear on one of these lists, it does not mean that it does not have a federally backed mortgage. And that's what people sometimes forget. The only way to really know, the owner of the property is allowed to access the information to find out who's servicing the loan and who owns the loan. And that's important too, because once people buy properties, the owner of the loan and the servicer, they can both change hands without the consent of the property owner. So just because someone bought a home and maybe it wasn't connected to a federally backed mortgage doesn't mean that later on it's not. And so it's really, really important to make landlords prove that they currently do not have a federally backed mortgage loan to show that they're not covered under the CARES Act if it helps a client. And only the, really, when you get down to it, only the landlord and the owner has access to that information. And if you want more information on why, if you reference the CLE I gave back in May, I did go into more detail at that CLE. Also, just so y'all know, HVL did a Texas Public Information Act request to Houston Housing Authority and the Harris County Housing Authority, asking for a list of all Section 8 voucher recipients, the landlords, not the tenants, but the landlords, for March, April, May, June, July, and August. And so if we do a check for any case that y'all take from us to see if that property of, if any of the properties of the tenants that we're trying to get y'all to help with, we see if those properties are covered by a Section 8 voucher, because if it has a Section 8 voucher, it's subject to the VAWA protections, and that's also a big thing. So if a person actually receives a Section 8 voucher, they'll know it and they know they're covered. Or they may not know about the CARES Act, but it's an easy way for us to know they're covered. The issue is when someone lives in an apartment complex, they don't know if their neighbors have Section 8 vouchers. And this is a way for us to find out if maybe someone in that apartment complex has a voucher. Because under the CARES Act, if one person in a multifamily property has a Section 8 voucher, every person in that complex is covered. Every single person. In case anyone is wondering, there are some landlords that have challenged that. In Harris County, most JPs have ruled in favor of the tenant when we show that there's someone with a Section 8 voucher, and on appeal, we've been successful with that as well. Just so you know, but not every JP court in Harris County thinks that. The other thing about the CARES Act that's still applicable today is Section 4024. That was the part about federally backed, that's about mortgage forbearance. It only applies to multifamily properties. So for people renting single family homes, this part just doesn't apply. And it's multifamily properties with a federally backed mortgage. If that property is in forbearance or has had a forbearance since March 25th, it applies. And if that's the case, the multifamily property landlord cannot give a notice to vacate or file an eviction while in forbearance. They have to give a 30-day notice to vacate after forbearance, and this section expires December 31st. This is important because this means that it is possible that there's a multifamily property in forbearance right now with a federally backed mortgage. And it's important to make landlords prove that that one, they don't have a federally backed mortgage, and two, that they're not in a forbearance in order for them to proceed with an eviction, because this section of the CARES Act is still in effect. And once the forbearance is over, they're all required to give a 30-day notice to vacate. So the next exciting thing that we have to talk about is the CDC Eviction Moratorium. This became effective September 4th, which is just 2 short weeks ago, and it's been a flurry of activity since then. It expires December 31st this year. Just so y'all know, it applies to all cases. It doesn't matter whether or not the case was an eviction case was filed prior to September 4th, or even if a judgment was already granted. The CDC Eviction Moratorium applies to all phases of an eviction, and that's from notice to vacate, filing an eviction, prosecuting an eviction means going to an eviction hearing and the landlord asking for judgment. It applies to the request for the issuance of a writ of possession, as well as the execution of a writ of possession. So it's exciting because it applies to every phase. And it also applies to all residential properties. CARES Act only applied to covered properties, which we think is, I don't know, at least 24% of properties in America. This applies to every single residential property. It applies to non-payment of rent cases. It doesn't cover other lease violations. And also, I didn't mention it before, but the CARES Act also applies to non-payment of rent cases. Generally speaking, for the moratorium, it applied to rent cases, but this applies to non-payment of rent cases. I mentioned that it's all phases of the eviction. It requires the tenant to do something. The CARES Act existed independent of any tenant action. The CDC Eviction Moratorium actually requires the tenant to give their landlord what we're calling the CDC Declaration. It's a declaration that this eviction moratorium applies to them. And it also says that tenants or landlords can be penalized for violations of the order. If a landlord receives a signed declaration from a tenant, then the landlord is not allowed to give a notice to vacate, file an eviction, prosecute the eviction, or request a writ of possession. I know we went through that, but I'm just emphasizing it. If a tenant tells a court that the tenant gave the declaration to a landlord, then the court is not supposed to grant the eviction or issue a writ of possession. And so this is exciting, and this is enforced by the emergency order that came out yesterday from the Texas Supreme Court. So this is exciting that the Texas Supreme Court acknowledges the importance of this and is making sure that every court in Texas follows the CDC order. I'm actually going to go through the CDC declaration now so everyone knows what a tenant is stating or declaring when they sign it. So one, they're signing under penalty of perjury. And the first statement is, I have used best efforts to obtain all available government assistance for rent or housing. Just so y'all know, generally that means calling 211 to find out what rent assistance is available to tenants. There isn't necessarily a lot of assistance available, which is unfortunate. The demand is much, much greater than the need. Baker Ripley is still accepting applications for rental assistance as well, and that is money that is mostly funded by the city and the county. I'll talk about that more in a little bit, but generally it means that they need to be calling 211 or other agencies that might be funded by the government to get assistance. It also says government housing. When I hear that, I think of things like Section 8 vouchers or actual like public housing. Those no one can even apply to get a Section 8 voucher right now. The wait list in Harris County and Houston, the Houston Housing Authority and the Harris County Housing Authority and the Houston Housing Authority, their wait lists are closed. They open them up, I don't know, maybe once every 7 years or so for up to a week. And then they're closed again for another 7 or so years. So that's very difficult. In case anyone is wondering, that's not easy to get into. And then most other places, a lot of them, it's property specific, which would mean that you would need to move to that property that might be covered. The next section of the declaration says, I either expect to earn no more than $99,000 in annual income for a calendar year 2020, or $198,000 of filing a joint return, or I was not required to report any income in 2019 to the IRS, or I received an economic impact payment, which is, AKA the stimulus check, pursuant to the CARES Act. We have not had a client that's applied with HVL that hasn't fit this section of the declaration. The next section or the next statement says, I am unable to pay my full rent or make a full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, layoffs, or extraordinary out-of-pocket medical expenses. Just so y'all know, it's actually defined by the CDC that extraordinary out-of-pocket medical expenses is 7.5% of gross income for 2020. The next section states, I am using best efforts to make timely partial payments that are as close to the full payment as my circumstances may permit, taking into account other non-discretionary expenses. When I finish going through the declaration, I am going to review this, but generally speaking, HVL is recommending that partial payments be 30% of income because federal housing programs, that's generally the standard is 30% of your income adjusted for utilities. And so, and if someone can't make even that much, we are suggesting attempting to make at least a nominal payment. The next section states, if evicted, I would likely become homeless, need to move into a homeless shelter, or need to move into a new residence shared by other people who live in close quarters because I have no other available housing options. The next part of the statement or declaration says, I understand that I must still pay rent or make a housing payment and comply with other obligations that I may have under my tenancy, lease agreement, or similar contract. I further understand that fees, penalties, or interest for not paying rent or making a housing payment on time as required by my tenancy, lease agreement, or similar contract may still be charged or collected. This is not a rent forgiveness program. Under all of the protections and programs, rent is still owed. None of the protections are a rent forgiveness, and neither is this one. And then finally, it says, I further understand that at the end of this temporary halt on evictions on December 31st, 2020, my housing provider may require payment in full for all payments not made prior to and during the temporary halt, and failure to pay may make me subject to eviction pursuant to state and local laws. So this does expire in a little over 3 months. And then finally, before a person signs, they're supposed to, this is on all the declarations. It says, I understand that any false or misleading statements or omissions may result in criminal and civil actions for fines, penalties, damages, or imprisonment. So people should read it, and if any part of this does not apply to them, they should not sign it. And for various reasons, even with HVL applicants, it's possible this doesn't apply to them. And I've counseled people already who, based on what they've told me, I've told them why I think it may or may not, but it's really up to the individual to decide. So the CDC Declaration is amazing and awesome, and I'm thrilled that it's a tool that we have to help protect people, but there are some issues with it. One is that the onus is on the tenant. The tenant's required to give it to the landlord. If the tenant doesn't give it to the landlord, there's no protection. We're advising all the tenants to document or record how it was given to the landlord. So we like email and we like fax. So because you get a fax confirmation sheet and an email, you can show it was sent. If someone is delivering it in person, we're advising them to take a witness or to record that they're giving it to the landlord. We're helping people e-sign the declaration. If someone contacts us and they don't have access to a printer, then we'll sign, and they think and they want to use it, then we'll send it to them so it can be e-signed, and then we will either fax it to their landlord for them. We don't fax it it comes from an HVL fax, but it's not sent from HVL, it's sent from the tenant. Or we will forward the e-sign document to the tenant so that they can give it to their landlord as well. Another issue is the best efforts. This is different for different people. Oh, just one second. Someone just asked a question. May the HVL volunteer lawyer email the landlord on behalf of the tenant? Absolutely, absolutely. If you are taking a case for a tenant, yes, because you represent them. When people are calling us, asking us for help, and maybe they haven't received a notice to vacate yet, and we have not accepted the case for representation, we don't want it to say it's from HVL, but if we represent someone, absolutely the attorney should send it. And if the landlord's represented, it should be sent to the landlord's attorney as well. So, so the best efforts. This is different for different people and for a variety of factors. I know that I've spoken to people that have called since the moratorium, since the CDC order came out, and I've said, have you applied for rental assistance? And they're like, what rental assistance? They are not aware that rental assistance is available. It might be because the tenant didn't need rental assistance before and they weren't paying attention. Maybe they only recently became unable to pay rent. So there can be different reasons. Another thing is some people are doggedly persistent, and they'll call every day even though they're told no every single day. And other people are homeschooling, or not homeschooling, doing learn at home with their children, are trying to work and do other things, and maybe they can't call every day. And I think every day is an unrealistic, and is a very unrealistic standard by the way. I'm just going to pause for 1 second. I'm going to see, my coworkers just texted me and said they couldn't see the questions, and I was going to see if there was a way to share it. I'm going to allow everyone to see all the questions, just so y'all know. Okay, so I hope everyone can see the questions now. And if you're watching on Facebook Live, it's my understanding that you can't see the Zoom questions. And quite frankly, I can't see the Facebook Live questions if there are any, but my coworkers are monitoring that. So thanks. Okay, so, and just so y'all know, for best efforts, we don't want there to be a standard, because different people have different, don't know about it, haven't known about it for as long. Maybe they self-selected and thought they weren't, it wasn't available to them because they're undocumented, which isn't necessarily the case for all government assistance, just so you know, or rental assistance in general. But, or maybe, I'm just letting, there might be different reasons. And so it's what the best effort is for that person. And in case anyone is wondering, the CDC Declaration, or the Eviction Moratorium, does not have a restriction on immigration status. I'm getting another question, and it says, can the signed declaration be presented to the landlord at any point? Yes, it can, and it should be. This is a new document, and people are still learning about it. I'm actually amazed in the beginning at what seemed to me to be very little media attention given to this. I think that will start changing as more people start using it. But if people didn't know about it and they're finding out about it now, they should absolutely be using it now if it applies to them. I said that I would talk about the partial payments. We're recommending 30% of income, or if no income, then a nominal payment. But everyone should know that I hear all the time from people, I tried to make a partial payment and the landlord wouldn't accept it. People should still try to make these partial payments, even if the landlord's not accepting them. I know that oftentimes landlords will lock tenants out of portals so they can't make online payments if they're late, and so that prevents it. And then they'll tell people when they go to the office, if they're like getting a money order or something, it has to be the full amount owed. The declaration says that they're making best efforts to make those partial payments, and so if they're trying to and the landlord won't accept it, they've still done their job. So the next, just 1 second, I'm not in the right screen. Another issue with the CDC order. I think that this is some of these issues, I think a lot of the issues on this slide are changing or will change because of the executive order that came out, the emergency order from the Texas Supreme Court that came out last night. I talked to a tenant who said that she gave one to her landlord, and the landlord said, I don't know what this is, but we're not participating and we're not a CARES Act property, and threw it in the trash. So the landlords don't get to decide if they're participating. It applies to all the residential properties. I guess the landlord can tell someone they're not it's not a residential property, but if it's a residential property, the landlord doesn't have a choice over that. Also, it applies to non-payment of rent, but it's possible that a landlord can use other, quote unquote, violations as a pretext to try to evict someone for another reason. So if the tenant likes to have parties, and it's never been an issue before, and I hope no tenant's having parties during COVID-19, but maybe playing their music loud at night. Maybe they're playing their music loud at night and they haven't, and it hasn't been a problem. Maybe now they say, oh, you haven't paid rent, but I can't evict you for that, so I'm going to evict you for being noisy. Tenants should be aware that that a landlord may try to use this as a pretext. I would be very suspect if someone told me they hadn't paid rent, but the notice to vacate was only for loud noise, and I would try to defend that under the CDC order, because I would say it was a pretext. If rent's not owed and a landlord doesn't list it, while they're not obligated to, it's highly suspicious. I can also say that over the past 2 weeks, I've heard stories or seen a misunderstanding of the CDC order by our local judges. So some of this I've heard from other attorneys, and so I haven't experienced it all personally, but I've heard that one justice court said it didn't apply to evictions filed prior to September 4th. That's not true. If you read the CDC order, it is clear that it applies, that it went into effect, and it applies at any phase of the eviction process. Another JP said it wasn't applicable because the declaration wasn't notarized. There's a difference between affidavits and declarations. Declarations don't have to be notarized under federal law or state law. And so there's, in case you're wondering what those laws are, there are links here. We also don't know if there's going to be legal challenges to the order. I know of one pending case in Georgia, but it doesn't seem to be having any effect so far. And also we're not in Georgia, so that wouldn't affect us here in Texas right now. And just another issue is the rent and the late fees are still accruing. So some tenants are going to face a bill that they simply cannot pay come January. So I just want y'all, I hope that Congress steps in, or state leaders, federal leaders do something to help the tenants pay their rent, because I don't think that all of them are going to be able to do it on their own because of the economic hardships they're facing due to the pandemic. If you actually want to read the moratorium order, the first part, the two links, it's the exact same text. The first one is a 37-page document. It's more spaced out, in my opinion, easier to read. The second one is the Federal Register. The National Housing Law Project has a nice overview at this link right here where it says overview, and they have an analysis of the order right here. And TexasLawHelp.org has plain language. TexasLawHelp.org is meant to be a resource for self-represented litigants or pro se persons. And so it's written in plain language, and it has, a sample declaration that tenants can use along with a cover letter that they can use to send to their landlord. And they also have the declaration available in multiple languages, including Spanish, Vietnamese, Arabic, and I also want to say Cantonese and Mandarin. So now we're going to talk about Texas Supreme Court emergency orders. In general, just so y'all know, courts are still not supposed to conduct in-person proceedings, contrary to guidance issued by OCA, which is the Office of Court Administration, regarding social distancing, maximum group size, and other restrictions precautions. The courts are supposed to be using all reasonable efforts to conduct proceedings remotely. And if you want to read more about the Texas Supreme Court emergency orders, the first one is a link to this will be your emergency orders from the Texas Supreme Court. And this link right here, the second one, is a link to the court guidance from the Office of Court Administration. Just so you know, we're seeing different JPs, I think, take this mandate differently. We see some JPs that have 40, eviction dockets with 40 cases on it. And we see a lot of others that are doing 10 or something much smaller. I will talk about virtual and remote hearings in just a minute in case anyone has questions about that. So Emergency Order 25, it requires all landlords who are filing evictions effective immediately, this was yesterday, through December 15th, 2020 to file it. The order actually says file a petition, but really almost everyone is doing a verification that states whether or not, 1, the premises is a covered dwelling subject to Section 4024 of the CARES Act, 2, whether the plaintiff is a multifamily borrower under forbearance subject to Section 4023 of the CARES Act, 3, whether the plaintiff has provided the defendant with 30 days notice to vacate under Sections 4024 and 4023 of the CARES Act. And this is, so FYI, these first 3 requirements had been in effect oh gosh, I don't remember when. These have been in effect for a little while. But this last one is a big one, and also what we're going to talk about in future slides that added the CDC to this verification, the CDC order. So number 4, the defendant has provided the plaintiff with a declaration under the Center for Disease Control and Prevention's agency order titled Temporary Halt in Residential Evictions to Prevent the Further Spread of COVID-19, i.e. the CDC order that took effect on September 4th. So the landlord, when they are filing their eviction, has to say whether or not they received the CDC declaration from the tenant. If they have already filed their lawsuit and they're showing up for the trial, they're most likely going to be given a new sheet or have to answer this question. Different judges, I can tell you over the past 2 weeks, some judges have already been asking some landlords this. Many judges have not. And so it's going to require the landlord to state whether or not it was given to them. So if anyone gets emails from Texas Rio Grande Legal Aid, you might recognize this language. An attorney at that office summarized the order this way, and I thought he did an excellent job, so I just copied and pasted it. It also, it amends the pleading requirements to state whether or not, so this is a summary of the entire order, in addition to what the landlords have to do in that verification. And the big thing is the new addition of whether or not the tenant provided the landlord with the CDC declaration. Secondly, it requires every new eviction citation to include information about the CDC order, a link to texaslawhelp.org, and it also has to include a copy of the CDC declaration form. So in Texas, after a landlord files the eviction lawsuit, they are served by the constable. Eviction lawsuits require service by a constable. It can't be done any other way. It can't be done by a private service process or anything else. So it goes to the constable's office, and it's saying that the citation has to include information about the order and a copy of the form for the tenant to use. That is huge. A lot of our tenants don't have access to printers. And so to make it available to them is just, it's enormous. It also confirms that a judge has the authority to question whether the tenant is aware of the CDC order and has had the opportunity to complete it, the declaration. So in court, the judge can say, do you know, and this is especially going to be applicable to the people who aren't going to get this future service with the information and the copy. So like the hearings happening today and on Monday, they didn't receive this information with their citation, and the judge is, it doesn't make the judge, but it makes it very clear that the judge is allowed to say, have you heard of the CDC order? And the judge can let them do it on the spot or abate it for a week or a few days to give the tenant the opportunity to complete the CDC declaration and give it to their landlord. It also makes it very clear that it requires an abatement of an eviction proceeding, including the issuance and execution of a writ of possession. If the CDC declaration that has been given to the court is given to the landlord is filed with the court. So the emergency order, if you read it carefully, states that technically it's only supposed to be filed with the court if the eviction proceeding had been filed prior to the emergency order going into effect. For practical purposes, I would recommend every single person, if they have a court proceeding, to file it with the court so the court is aware that the landlord has it. They still are required to give it to the landlord, but it's the tenant's way of letting the court know that it was given to the landlord. And it also says that an eviction in which a CDC declaration has been filed with the court, this is the one caveat, or I don't want to say the caveat, but landlords are allowed to contest the CDC declaration provided to them by the tenant. And this is the only circumstance in which an eviction is supposed to proceed. They have to have a hearing, and the judge has to sign a written order stating why the eviction should proceed and the procedures for it to proceed. And so I'm anxious to see what those written orders might look like and how landlords, I'm curious to see if landlords plan on contesting it or not and to what degree. But I do expect that some will. And so that's the only time that anything is supposed to move forward. Now we're moving on to Houston and Harris County protections. Technically, there aren't any. Neither Harris County nor the City of Houston has enacted any ordinances or rules regarding tenant protections at this time. However, the Baker Ripley assistance is funded mostly by the city and county. There is some grant funding in there as well. And if a landlord receives rental assistance, or if the tenant applies for it and the landlord receives it, there are strings attached to receiving that assistance. The terms of the landlord participation can be used as a defense in court. And I can tell you by watching and observing trials that the judges don't know what the terms are, because I've seen tenants testify that they were approved for it, it just hasn't, and it's supposed to be paid in 5 days. And I'm seeing judges allow cases to proceed. And so it's clear to me that the judges aren't aware that this Baker Ripley rental assistance comes with strings attached. And I can tell you that landlords are filing and prosecuting these evictions in violations of the rules and the agreements that they've signed with Baker Ripley, and I guess in order to receive this money. Generally, it says they have to give them credit for partial payments. They have to waive late fees. They have to rescind or cancel prior notices to vacate. They're not supposed to interfere with the tenant's possession of the unit. I take that to mean several different things. I think it means not locking someone out. I think it means not shutting off the utilities. I also think it means not prosecuting an eviction or requesting a writ of possession. It says they also have to confirm amounts of unpaid rent of a tenant. It strikes me as ridiculous that that has to be listed as a term, but some landlords become very uncooperative with tenants when there's late rent owed. And it also says that they are obligated to post payments to a tenant's account within 5 business days of receiving any payment from Baker Ripley. Whether or not a landlord receives assistance, they can get it with city money or they can get it with county money. If they get it with city money, these are the city rules that they have to enter into a payment plan and let people catch up beforehand. And they also have to enter into a payment plan for when they're receiving the rental assistance in case the rental assistance doesn't cover all of the rent owed, to allow tenants to get caught up. And that's if it's a city funded rental assistance. Within Baker Ripley, there is a participation directory, and it says whether or not it's city, county, or both. And so it does require a little bit more, but just understand it is different for city versus county. The county terms are that they have to discount total past due rent. They have to enter in a payment plan. They are not supposed to give the tenant a notice to vacate for at least 60 days from the date they receive payment from Baker Ripley. It also says they have to participate in mediation. We haven't received any requests for mediation, like assistance with mediation, but that's before filing another eviction suit. And just letting you know, I haven't heard much about that aspect of the requirement. This is a link to the rental assistance directory. And if anyone has a client who has received or has been told by Baker Ripley that they're being approved, they should read the FAQ to understand what the rules are that apply to the landlord. Also, I don't know if y'all been paying attention to the news or not, but Mayor Turner has been urging residents, let me back up. Generally speaking, the way the program works is first the landlord has to apply, and in order for a tenant to be eligible for renter assistance with Baker Ripley, they have to find their landlord's name in the participation directory, and then they choose apply. And it hasn't been possible for people whose landlords aren't participating. They haven't been able to apply for rental assistance with Baker Ripley because it required that landlord participation. Mayor Turner has been telling people to go ahead and apply because they're going to open it up to tenants whose landlords have not applied. One of our staff members called Baker Ripley this morning to try to figure out how that's working. And what she reported back to me this morning is that they've opened a waiting list for tenants to add their name to receive funds, but that they haven't finalized the plans or updated the website. This is the phone number. It's 281-272-6478, so that tenants can add their names to the waiting list. The tenants can also call the sign-up hotline once the program opens, and they'll be able to apply. And we don't know when this will go into effect. And also, just so y'all know, I don't know if you remember back in May, Baker Ripley had, what was it, $15 million of rental assistance that ran out in 60 minutes. I know they said it was 90 minutes, but they said it didn't work for the first 30 minutes. So really it ran out in 60 minutes. There are still some people, I know an attorney who had a case whose tenant, whose client had received this May Baker Ripley assistance, and the landlord filed an eviction in violation of that agreement. And so just be aware that you should check to see when it happened, because the rules are slightly different. Okay, so because of the CDC order, we are expecting an uptick in self-help evictions, what are generally known as lockouts and utility shutoffs. And that's when landlords aren't able or willing to obtain relief from the courts, which is the only legal way. In order to evict someone, you're required to go through the courts. And so some resort to their self-help remedies. Lockouts are governed by 92.0081 and 92.009 of the Texas Property Code. And utility shutoffs are governed by 92.008 and 92.0091. I'm not going to go into what the requirements are, when it's legal, when it's not legal, but generally speaking, landlords are not supposed to lock people out, and landlords are not supposed to shut off utilities. So for lockouts, the rules state things like, if a landlord intends to do it, they have to give notice beforehand. When they change the locks, they're required to post it with a notice with a telephone number that can be called 24 hours a day, and a new key will be given to the tenant within, I think it's 2 hours of calling. And rent, and even if rent is owed, they cannot demand rent payment when they're delivering that new key. Utility shutoffs, I'm not going to go into it, but if you want to read it, that's here. If we are asking you to take a self-help eviction case, we've already done some pre-screening to make sure it applies, but almost always it applies. I do want to note one thing though. If a landlord is not repairing a broken AC, generally speaking, under the Texas rules, if rent isn't paid, or if there is unpaid rent owing, then a landlord is not obligated to make repairs. That is different than a landlord shutting off access to an AC. If the landlord interferes with that utility, that is not allowed. If the landlord's not repairing something, that's different. The process for lockouts, for getting a writ of reentry for lockouts or writ of restoration for shutoffs, is pretty much the same for both. The process is the same. The applicant files a sworn application. That's normally the affidavit, or you can use the unsworn under penalty of perjury declaration allowed under the Texas law. There is a filing fee, but our HVL clients 99% of the time qualify for a statement of inability to afford payment of court cost, so the filing fee is waived. There's supposed to be an ex parte hearing that day. If the judge finds at that ex parte hearing that there was an unlawful action, then the judge is supposed to issue an ex parte writ for immediate and temporary restoration in the case of utilities, or possession in the case of a lockout. The writ is then supposed to be served on the landlord. The landlord can request a hearing within 8 days, and the hearing is supposed to be held 1 to 7 days after a landlord requests a hearing. At that hearing, the judge can either keep the writ in place or dissolve it based on the testimony heard. If it stays in place and the landlord does not comply, then the tenant can file a motion for contempt, and a landlord can be jailed if they still don't comply. We have had several attorneys take some of these cases already, and I've had a coworker take one, and I've also spoken with various legal aid providers around Houston, and these are the tips I have heard from everyone. The first one is, be prepared to prove everything. The damages, Just so y'all know, both of the sections of the property code pertaining to shutoffs and lockouts provide for statutory damages and attorney fees. And also if you have actual damages, like if you're locked out and have to go to a hotel, that would be an example of a damage as well. So be prepared to prove everything at the quote unquote ex parte hearing. The reason why I call it a quote unquote ex parte hearing is it is not uncommon for a judge to reach out to the landlord and either invite them to that ex parte hearing over the phone or in person. And so sometimes they might be on the phone or not, but because the judge gave them notice, they don't necessarily consider it a typical ex parte hearing. And if you're only having one hearing, then you need to get everything done at once. Just because it may not be granted at that first hearing doesn't mean you shouldn't be prepared to prove it up. Another thing is you need to push to get the hearing set. When we've had attorneys involved in these cases, we like to file things and get the hearing set. I had a case in which one volunteer attorney told me that they e-filed the application and it wasn't being accepted. And he called the court and they're like, oh yeah, we see it here, but they still wouldn't accept it. And so the hearing wasn't being set because they weren't processing the application. And then I had another instance in which another attorney told me that, she filed it, they accepted it off the bat, but they set the hearing for a week later, which is outrageous. And so sometimes the person processing may not understand. Always ask to speak to the chief clerk. The chief clerks generally understand the rules and understand they're supposed to happen. Another thing I just want to suggest, and this depends on who's doing it. Another option is if the tenant is comfortable and isn't like maybe high risk for COVID, maybe having them go to the courthouse to file it and saying, and my attorney's prepared for the Zoom or phone hearing later this afternoon so that it can still move the way it's supposed to move, which is same day. Damages awarded in a lockout or utility shutoff case can be used to offset the unpaid rent. And so that can be helpful for a client, especially if this is happening to them, but it can help them with their balance. And then I've heard this from several people. Some judges seem to be reluctant to sign orders. So if that's something you're experiencing, like maybe they'll have the landlord on the phone and they'll say, okay, landlord, I need you to unlock this, right? And the landlord says, sure. And the judge doesn't want to sign the order. If you're experiencing that, please push the judge to commit to when someone has to do something, when the landlord has to do something, and what the judge wants you to do if they don't do it by that time. Especially if they're saying they don't want to sign the order, just push a little. And the Texas Justice Court Training Center has charts and checklists that kind of show the process. They also have pro se forms, but the pro se forms do not have, they don't request damages. Okay, after my last CLE in May, we were very concerned about getting virtual hearings. So that's not really an issue. Many of the JPs are offering Zoom hearings. I'm being told that the reason why not all of them are is because of technology issues, like they don't have all the technology required to have a Zoom hearing, but I'm told that they're all working to fix that. Every single JP will offer a phone hearing, and you don't have to file a motion. You just email or call the court to find out. You say, like, I want a Zoom hearing. If they don't have it, then they'll tell you can do it by phone, and they'll tell you like what they need in order to get you on. Normally it's an email to the court and they'll email you back. For county court at law, all of those hearings are only taking place via Zoom. And if anyone wants to watch any of these hearings, this is a link to Harris County Courts, the live stream for JP and County Court at Law. It also has the County Criminal Courts at Law. I haven't watched any of those, but when you click on it, it'll show a list, like it'll be lit up in green for anyone who's live streaming at the time. And it's very interesting. I urge everyone to do that. Just so y'all know, for court filings, e-filing's free through the state e-filing service. For HBL clients, we do it with a waiver account, and we use a statement of inability to afford payment of court costs. And when an attorney is representing someone, you normally attach a legal aid certificate to that. Just so you know, most JP courts don't require things to be e-filed. Almost every single one will accept filings via email to the court clerk. And so you should always call and find out what the preferred method is. Some of them will accept it via fax as well, and it can help speed things up sometimes. If you have a case in county court at law, which is where all the eviction appeals take place, they do require e-filing. Then they will only be accepted via e-filing if an attorney is involved. I just want to remind it, I don't want anyone to walk away today and say, that woman said that rent doesn't have to be paid. Rent has to be paid. None of these moratoriums or protections are rent forgiveness, not one single one. I want to remind everyone that people should be applying with Baker Ripley or calling 211 for rental assistance. If you know anyone having problems, they should call. I am going to tell you, even though they should be calling, I've also been called back by people and they say, they gave me the names of 3 places and 2 of them told me they're not accepting applications and the other one wouldn't answer the phone. Not everyone's getting money. And I just also want to let y'all know that some people, I don't hear it as much anymore, but some people might have given up on trying to get their unemployment sorted out, or some people are having a hard time surviving on reduced benefits, just so y'all know. So someone is asking how to request slides. I think that Brittany might be emailing them to everyone who enrolled. And if Brittany can answer me, I would appreciate that. So maybe she doesn't get flooded because I think she might just send it to everyone who's attending. Just so y'all know, if you know other people, like pro se resources are available at Texas Law Help and also at the Texas Justice Court Training Center. If you want to read about other protections across Texas, Texas Law Help has information on that. And this is my call to action. Tenants really need your help. I know that I just went through like all these great remedies. The issue is that if an eviction is filed against someone, it can make it difficult for them to find another place in the future. And really why tenants need your help is because landlords don't always follow the rules and tenants don't understand them. We want to make sure that the law is applied and that tenants receive the protections available to them. Eric Qualtler at South Texas College of Law did research and he pulled every single filing filed in Harris County between March 27th and July 25th, which is when the CARES Act eviction moratorium was in place, and compared it to publicly available data about properties that have federally backed mortgages available from those public lists. And we also shared with him our Texas Public Information Act request regarding who's receiving Section 8 vouchers, which properties are. And he found that nearly 24% of all evictions filed in Harris County during this moratorium were illegal. They should not have been filed. And just so y'all know, these Supreme Court emergency orders have been requiring landlords to say that they're not covered. And we can look it up and see that they are. And I think there's 2 things going on. Sometimes they just want their money, and other times the person filling out the form doesn't know or doesn't even understand the form they're filling out. They come to the courthouse and I think the clerk says, oh, by the way, this is required, and they just sign it. Because I've heard other legal aid attorneys ask them, like, how do you know this? And then they'll admit in trial that they don't know what they just signed. And so that's why, even though these protections exist, we still need representation. Because when I watch these trials online, which you can do too, I can see tenants that have defenses, but they don't know how to explain it. Just so y'all know, when the CARES Act came out, the Congressional Research Service said about 28% of renters probably had federally backed mortgages, were living in properties with federally backed mortgages, plus there's additional people with with the VAWA protected properties. It's our duty to give good information and set realistic expectations for clients. Sorry, I'm speeding it because I know I'm running out of time. We want everyone to know that rent's still owed and we can't simply take care of it. And we can also give them, I just think that sometimes having someone get legal advice, it can be so valuable instead of my friend told me this or I read something on the internet. It can be really important. The other thing is that we can make landlords prove their cases. So like I've been to court and I've asked a landlord, do you have a federally backed mortgage? And she's like, I'm not prepared to answer that. And the judge goes, okay, well then we'll reset this so you can answer this. That's a help to people. Someone asked, how do you get access to watch these eviction hearings online? I'm going to go back just a little bit and show you. It is on this screen where it says virtual hearings. This link here at the bottom is how you can watch these cases online. Thanks for the question. I'm going to keep going now. Sorry. Tenants deserve to have their rights protected. And just so y'all know, landlords do have options too. If they're under the CARES Act, they can get forbearances. So if you take a case, and please sign up to take a case. We will help you. We have an updated volunteer guide to take into effect that things have changed since we first wrote it in May. We have a notice of the CDC Declaration and the CDC Declaration if you want to use it for your client. We have forms for the writ of restoration and writ of reentry. We have a motion to dismiss for baseless cause of action, the appeals form if you want to help a client appeal, and also some simple settlement agreements. If you want something more complex, you can reach out individually. So if you take a case, any of these documents will be made available to you. We also have, if you want to read anything, everything in here was linked already within this deck, but the Emergency Order 25 was linked to on the Texas Supreme Court COVID page, the CARES Act, the CDC Eviction Moratorium, and my old CLE, this is the link for it if you're wondering more about eviction basics. These are other helpful links. I'm sorry, I'm going really fast now. And I want to give a huge shout out to everyone who has taken a case and made a difference in a tenant's life and helped them protect their rights. So thank you, thank you, thank you. I hope that, just so y'all know, if you signed up for this case today, you are being added to our volunteer pool list for evictions. If you want to be removed, please email Brittany either now, or if she emails you later and says, are you available to take this case? You can let her know you want to be removed from the list. If you're just busy at the time and can't take it then, you can email her and say, sorry, I can't take it right now, but leave me on the list. If you know any friends or coworkers who you think would be interested, have them email Brittany to be added. And just so y'all know, a trial in JP court is usually shorter than a hearing in district court. These are quick turnaround cases. The rules of evidence don't apply in JP court. It's just a fast turnaround. If you're interested in other cases, you can still sign up at hbl.legalserver.org, and all of these slides and forms will be available to you. This is the CLE information for today. If you have questions about landlord-tenant issues, email me or my coworker, Mari Carmen Dollar. If you have questions about volunteering, please email Brittany. I'm just going to flip over real quick. If you have questions about the abbreviations, they are on the last slide. I'll leave this back up and take questions. So I can't see any Facebook Live questions. So I don't know if y'all are doing that. I can only see them on the Zoom. And if anyone has questions, I will stick around for a minute. But otherwise, thank you for attending today. And please take a case. I am apologizing. I'm seeing a Q&A and I'm seeing the chat, and I'm just now seeing the chat. So I apologize, guys. Okay, someone has asked this. The signed declaration can be presented to the landlord at any point. Yes, it can. It looks like that was the big question. What does the process look like when a landlord challenges a tenant declaration under the CDC moratorium? They have to have a hearing. If there's already an eviction trial scheduled, I imagine that the hearing would just be at the eviction trial. And depending on what the judge thinks about the tenant's answers or the landlord's challenge of it, I think the judge would then either abate the case right then and there or allow the eviction trial to proceed, is the way I imagine it would happen. If it's at another point in the process, like maybe they lost last week and this week they're filing something with the court that says, I gave my landlord the CDC declaration, I'm filing with the court, so no writ of possession should be issued. At that point, if the landlord wanted to challenge it, they would have to set it for a hearing. I see that the court web streams link is posted. I'm looking for other messages. The copy of the presentation, I believe I think that Brittany's already planning on mailing it to everyone. And I don't see any other questions. I really want to thank everyone again. I hope they all have a terrific weekend, and I hope that everyone just gets some rest and relaxation.